seem hard to believe that the concept of disability discrimination has been with us now for nearly 19 years. Almost as hard to believe is the fact that I was still at primary school when the Disability Discrimination Act 1995 first came into force, and only in my early 20s when it became embodied in the Equality Act 2010. But disability discrimination has been a massive growth area in employment law, and one that's developed very quickly, and which to this day still causes managers and HR professionals some major headaches.
So why is this still an area that causes problems at the coalface? Well, a good starting point is to look at what the meaning of a disability is. When the concept of disability discrimination first came about, it soon became obvious that disability covered far more than the obvious physical disability and the classic stereotype of the orange badge holder. In fact, the scope of the definition went far beyond what laymen and lawyers ever had expected.
A person has a disability if they suffer from either a physical or a mental impairment which has a substantial and long-term adverse effect on their ability to go about normal day-to-day activities. Long-term means that the condition has already lasted or is likely to last for 12 months or more. And if it does, then it potentially qualifies for protection. The individual also has to show that the condition impacted on their ability to do normal day-to-day things, and if it did, that impact was significant, because then that amounts to a protected characteristic.
And this is well demonstrated by our next case, London and South East Railways and Adarami. Mr. Adarami was employed by the railway as a station assistant from 2003 to 2010, and his duties included checking tickets, operating automatic gates, and as you might imagine, involved prolonged periods of standing. Unfortunately for him, spending much of his working day on his feet caused him to suffer from lower back pain. His back condition got progressively worse, and by late 2009, it had reached a point where he had to take 2 months off work. He returned to work and was certified fit for normal duties. But his problems continued, and 4 months later he was absent again with severe lower back pain. After a month of sickness absence, he was classified under his employer's medical scheme as fit to work, but with limitations, namely that he found standing for prolonged periods and bending very difficult. 3 months after this, he could only stand for periods of 20 to 25 minutes, after which he'd need to sit down, and he was unable to undertake any duties at all which involved bending or lifting. The railway company reassessed him on 2 separate occasions, and on the last occasion in October 2010, the feedback remained the same, that he was fit to work but with the same limitations. An occupational health expert regarded Mr. Adarami as significantly restricted in his mobility, and that he was continuing to suffer with a high level of discomfort. He was ultimately dismissed on health grounds because he was not able to return to his contractual duties, and the medical evidence was that he wouldn't be able to do so within the foreseeable future. There were no other roles that could be offered to him which he could do because of the back problems that he had and how they affected him. So he claimed that his dismissal amounted to disability discrimination.
Now, the tribunal accepted that he was suffering from a physical impairment, so in other words, his lower back condition, but they didn't feel that it actually went over the sort of substantial threshold, or that it had a long-term adverse effect on his ability to do normal day-to-day things. Because what the tribunal did was that it focused on what Mr. Adarami could still do. He could still walk, he could still stand, he could still lift light items, he could wash up, he could dress himself. And because of that, the employment tribunal said that his condition hadn't passed the threshold as being significant and so didn't qualify as a disability.
But Mr. Adarami appealed against the decision to the EAT, and the EAT decided that spending significant amounts of time standing at work was a normal day-to-day activity. In addition, when considering whether his impairment had a substantial adverse effect on his ability to carry out normal day-to-day activities, it decided that the tribunal should have focused its attention on the activities that Mr. Adarami couldn't do. It was evident to the EAT that on that basis, Mr. Adarami's back condition did appear to impact on his ability to do normal day-to-day things. He couldn't sit or stand for prolonged periods without serious discomfort. He was severely limited in what he could lift or carry. He couldn't bend down low or for too long. The EAT has sent the case back to the Employment Tribunal to reconsider whether Mr. Aderami's back condition amounted to a disability when taking into account what he couldn't do any longer. £1 to a penny, the decision on whether he suffered from a disability at the time of his dismissal is likely to be reversed.
So what's the practical point in this case? Well, this is actually quite a common error. And we often see employers, when they're trying to assess whether an individual is suffering from a disability or not, they're assessing what the individual is still capable of doing. And because they're satisfied there are still many things that the individual can do, they then assess that there's no disability. And actually, they're looking at it the wrong way round. What they should be concentrating on and what you should focus on is what the individual can't do. And unless what they can't do is a highly specialised thing, so it might not then be classed as everyday activity, then providing the impact still appears to be significant, it's always best to err on the side of caution and deal with the case as if it's one where a disability is involved.
Well, if you have an employee who suffers from a disability, this is when the duty to consider reasonable adjustments kicks in. If you overlook that duty when dealing with a disabled employee, then you're looking at a one-way ticket to a successful discrimination claim. The duty to consider reasonable adjustments is one of the main areas where employers get themselves into hot water. But what does the law require you to do?
Well, where there's a working requirement, or the physical features of the workplace, or a failure to provide an auxiliary aid place a disabled employee at a substantial disadvantage in comparison with someone who doesn't suffer from their disability, you come under a duty to make reasonable steps to avoid that disadvantage. And there are fairly obvious examples. So if, for example, you have an employee who's partially sighted and part of their role includes the use of a computer to do their work, then investing in equipment, so speech synthesis software or screen reading software, that would help remove the disadvantage of the partially sighted employee compared to somebody with 20/20 vision. And that is something that, in the vast majority of cases, you'd be expected to do as a reasonable adjustment.
If workplace rules disadvantage a disabled employee, then the requirement to make reasonable adjustments would require a workaround to be found, or potentially the relevant part of the standard policy to be disapplied for that particular individual. But who actually decides whether the adjustment is reasonable or not?
In the Fuller case, Mrs. Fuller said that she'd been placed at a substantial disadvantage by the council's requirement to keep the windows open during winter months because of the fact that it was hot and stuffy, and that was done to ensure the comfort of the other employees. But what she said is that the cold drafts that this produced exacerbated symptoms of her asthma and her sarcoidosis. And she resigned, and as part of her claim, she said that the council had failed to make reasonable adjustments. Well, the council argued that it had attempted to do just that, because it had offered her the opportunity to hot desk so that she could work away from open windows, but she complained about that. So then they offered her a temporary assignment to work at a different office, but she again refused that. And her claim ultimately failed because the council had made, or at least they'd offered to make, reasonable adjustments.
Now, the practical point here is that the duty to make reasonable adjustments is relatively flexible. It wasn't open to Mrs. Fuller to simply say that the practice of having the windows open should simply be abandoned. The council looked at and offered sensible alternatives which would have allowed her to continue working in her role, and perhaps which she shouldn't really have sniffed at. So, in this case, the council didn't catch a cold and managed to successfully defend her claim. So when it comes to thinking about making reasonable adjustments, providing you've genuinely tried to overcome the problem and have offered alternatives which are reasonable, then the fact that the employee may not necessarily agree with you will not be fatal. It's of course sensible to try and flush out what their objections are though, but if the proposed adjustments essentially overcome the disadvantage, then a refusal of them by the employee shouldn't leave you exposed to a successful claim.
Now, we've had a couple of interesting cases which have looked at the question of rehabilitation and how far the employer has to go in offering that when considering making reasonable adjustments. In Croft Vets and Butcher, Mrs. Butcher was an administrator who suffered from a long-term depressive condition, and she was absent from work because of that depression, which was in part made worse by work-related issues. So the vet practice asked her to go and see a consultant psychiatrist so that they could be provided with an opinion on relevant occupational health issues. One of the psychiatrist's recommendations, though, was for the vet practice to consider funding a limited number of sessions with a clinical psychologist and also a limited number of psychiatric sessions. And whilst it was clear that there was no guarantee that that private treatment would bring forward the return to work date, the psychiatrist was hopeful that that would be the outcome. But it became clear to Mrs. Butcher that the vet practice wasn't going to fund that treatment, and she resigned and made claims of disability discrimination and constructive dismissal. And she succeeded in her claims, but then the vet practice appealed to the EAT.
Now, the issue that the EAT had to consider was whether funding of private medical treatment came within the duty to make reasonable adjustments, and they decided that it did in her particular case. The EAT said that the requirement for employee to return to work was a provision, criterion or practice that Mrs. Butcher was facing, and which disadvantaged her compared with an employee who was on sick leave but not suffering from depression. A person without depression wouldn't have been away from work for so long, and so no disadvantage would have been suffered by requiring them to return to work. They decided that there was enough of a prospect that the recommended treatment would overcome the disadvantage in order for the duty to apply. But they were careful to highlight that their decision did not mean that employers should be funding private medical care in general. This was a specific form of treatment which would have allowed Mrs. Butcher to return to work earlier and cope with the difficulties that she had experienced in the workplace. The fact that her absence was linked to stress at work was a factor that was taken into consideration. Now, it's an interesting case, and it shows that there is potentially a very fine line between what is considered to be a reasonable adjustment and what is not. Private medical treatment is generally obtained in order to eliminate or reduce a medical condition or its impact, so the decision is therefore potentially wide-reaching.
But we think there are two aspects of this decision that probably avoid it becoming a precedent that requires you to fund rehabilitative treatment in all disability cases. Firstly, it seems that there was little or no consideration of the availability of the recommended treatment through the NHS. So if the NHS could have provided the treatment that the psychiatrist was recommending in relatively quick order, then it wouldn't then be a reasonable adjustment to expect the employer to fund it on a private basis. So you should always check that out.
Secondly, the recommended treatment in this case was not designed purely to bring forward the return to work date. It was felt that it would help with some of the workplace factors that had caused or contributed the absence in the first place. And that's an important strand of this decision. But having said this, if you are faced with situations at work where an employee is suffering from long-term sickness absence, which could amount to a disability, and if there are workplace features which have caused or contributed to this, then it becomes more likely that paying for treatment would be classed as an adjustment that you should be making.
Rehabilitation was also the issue in Secretary of State for Work and Pensions and Higgins. In this case, Mr. Higgins was a long-serving employee at Job Centre Plus in Liverpool. But in June 2009, he began a long period of sickness absence due to a debilitating heart condition. In August 2010, Mr. Higgins presented his employer with a fit note, which said that returning to work on a gradual basis would be desirable. The job centre offered him the opportunity to build up his normal contractual hours over a 13-week period, which was in line with that medical advice. But Mr. Higgins immediately refused to return to work on that basis unless the period was extended to 26 weeks. The job centre refused his request, and in the end, because there was no agreement on this point, they ended up dismissing him. And he claimed, amongst other things, that there had been a failure to make reasonable adjustments for him as a disabled employee by failing to consider that extension for his phased return to work.
Initially, the Employment Tribunal agreed with Mr. Higgins, saying that there had been a failure to make reasonable adjustments by failing to consider an extension of the 13-week period from the off. But on appeal to the EAT, it was decided that there was no failure to make reasonable adjustments. The EAT felt that there was no obvious disadvantage to Mr. Higgins in failing to agree the extension from the outset, because at the time the decision was taken, no one knew what the future might hold at the end of that recommended 13-week phased return period.
The EAT commented that employers are often presented with fit notes recommending a phased return of a certain duration. And the EAT noted that if at the end of the agreed period an employee continues to suffer a substantial disadvantage, then although the duty to make reasonable adjustments will still apply, it's got to be judged on the individual circumstances at that time. So the practical tip here is that this decision does appear to give some support to the wait-and-see approach. In other words, when a GP issues a fit note suggesting a phased return to work, it's going to be acceptable for you to delay any decision about whether you're going to extend that period or not to the end of that initial phased return period, even if the employee seems to be objecting to it. I mean, it's common sense to keep phased returns under constant review and to revisit the question of whether a further extension of the phased period needs to be made if the hoped-for improvements in the individual's health don't materialise. But obviously, if at the end a further period of reduced hours or perhaps reduced job duties mean that a full return is going to be more likely, that is still going to be a reasonable adjustment that in most circumstances you should consider making.
Where an employee is unable to continue in their current job as a result of a disability, the duty to make reasonable adjustments will often extend to taking positive steps to facilitate their redeployment. The case of Wade and Sheffield Hallam University does highlight, however, that employees with disabilities need not be given favourable treatment in the sense of promoting them to jobs beyond their qualifications or experience. Mrs. Wade, who was a disabled employee of the university, found that her role was made redundant. She applied for another role within the university, was interviewed, but she failed in 2 core competencies and was therefore considered not appointable to the role. Following this decision, Mrs. Wade brought various disability discrimination claims against the university, including that they should have made the reasonable adjustment of waiving the competitive interview process.
Now, it was accepted that the competitive interview process was a provision, criterion or practice which put Mrs. Wade at a disadvantage due to her disability. And the Employment Tribunal decided that it wasn't going to be a reasonable adjustment to require the university to dispense with that process, because actually that would have placed the university in a situation where it had to employ somebody who genuinely wasn't suitable for the role. She appealed, but the EAT upheld the tribunal's decision. They said that disapplying a competitive interview process wouldn't be a reasonable adjustment in every case. So clearly a common sense decision that's to be welcomed, because it would have been nonsensical to place her in a situation where she wasn't going to be able to do the role. But there are going to be cases which would go the other way, so you do still need to be careful. It's very much going to depend on the roles in question.
Again, this is an area where we would recommend that you take some advice before making a final decision. There will be cases where the individual does have the skills to undertake the role, and in those cases it's more likely to be reasonable to simply just slot them in, even if your normal procedure would be to interview for the post.
Okay, moving on, we're going to look at the case of Novak and Phones for You. Whilst this question looks at time limits and when a claim can be brought and when time begins to run, which is of interest to lawyers, it's perhaps more of an example of how social media can inadvertently lead to you facing a claim. Mr. Novak suffered an accident at work when he fell down some stairs. And not long after that accident, whilst he was on sick leave, one of his colleagues posted something on their own Facebook account, and it was actually a photo of himself lying at the bottom of stairs in the same position that Mr. Novak had found himself in after his fall. He became aware of that post, and he complained to his employer, and it was then taken down. But 3 weeks later, another of his colleagues also posted comments on his Facebook page, but this time ridiculing Mr. Novak's fall. And then other employees signified their approval of those comments by giving them the thumbs up. So over about a 2-month period, comments were being actively made about him, but then they remained dormant on the site for another 2 months, but again, eventually were taken down. But shortly after those comments were removed, a further Facebook post materialised, and once again, two of his colleagues made further comments which were derogatory about him.
Mr. Novak made claims of disability discrimination. Phones for You attempted to argue that some of the incidents were time-barred, as more than 3 months had elapsed from the time that the comments were made and Mr. Novak commencing tribunal proceedings. The tribunal decided that the earliest posts were separate and therefore out of time. Mr. Novak appealed against this decision, and the EAT decided that he did have a good arguable case, that the entries all formed a single continuing act of discrimination. They were linked by the subject matter, the people making the comments, and despite being separated by 7 weeks, it was arguable that they were also linked in time. And because of this, his claims were allowed to proceed to a full hearing.
Well, the practical point here is if you become aware of inappropriate social media postings, just take steps to get them removed immediately. One of the issues here in relation to the time limit was the question of whether there'd been activity on Facebook. And whilst there hadn't been any activity, the post still remained visible. And for that reason, that's why time was continued to run continuously. It also just shows the joys of Facebook.
We'll turn now to look at some cases on race and religious belief. The main focus of the case law over the last 12 months has been the application of the victimization provisions in the Equality Act. In order to succeed in a claim of victimisation, an individual must show that they have suffered a detriment, essentially some kind of disadvantage, and that this was meted out because of a protected act. A protected act can involve the individual complaining of having suffered unlawful discrimination, for example if they raised a grievance, or by making a claim. It can also cover situations where the employee has assisted someone else, for example by acting as a witness or a representative. There has to be a causative link between the protected act and the disadvantage suffered. If the disadvantage was actually suffered for another reason, for example because of absenteeism or conduct, then clearly a claim of victimisation would fail.
Now, the Woodhouse case is a salutary tale for employers. One employment tribunal claim is often more than enough for most employers to have to deal with, but imagine not just one, but 7 claims to defend, and in addition, another 10 grievances to hear. And then consider how you'd feel and how you'd react if those had all been raised by the same employee. Well, Mr. Woodhouse, a black employee, brought various grievances and tribunal claims against his employer over a 4-year period, each of them alleging race discrimination. And almost all of them, grievances and claims, were found to be empty allegations without any real evidential basis to support his suspicion that he was being discriminated against because of his race. Now, it's perhaps not too difficult to put yourself in the shoes of his employer and appreciate that the various claims and grievances that were raised by him would have resulted in a less than harmonious working environment. But eventually, and perhaps to some extent unsurprisingly, his employer considered that there'd been a breakdown in trust and confidence to such a degree that they just felt it wasn't possible for Mr. Woodhouse to continue working for them any longer, and so they dismissed him.
But the story doesn't end there. Mr. Woodhouse then lodged his 8th claim in the Employment Tribunal, alleging that his dismissal was an act of victimisation. And ultimately it was decided that he had been subjected to a detriment, namely his dismissal, as a result of raising grievances and making claims. There was no suggestion that he had acted in bad faith when he'd made his claims and his grievances. He genuinely believed that he was being discriminated against, and because of this, his claim succeeded. Now, from a legal perspective, the decision makes sense, but it does leave you with some sympathy for the employer. The case is a useful warning to you all that no matter how unlikely or unfounded discrimination grievances or claims may be, provided they've been made in good faith, an employee should not be dismissed because of having raised them.
Okay, now, still with religious beliefs, there was an interesting tax case. Now, I appreciate that's quite a considerable oxymoron, but don't switch off, because this case, even though it's about taxation, is still relevant to employment law.
Okay, the case with the long name, Blackburn and another trading as Cornish Moorland Honey and Commissioners for HM Revenue and Customs, The first-tier tax tribunal had to decide whether the legislation that requires all VAT returns to be submitted online infringed the rights of Seventh-day Adventists. A group of Seventh-day Adventists argued that they chose not to use computers, saying that this was a manifestation of their religious belief. The tribunal decided that there was a sufficiently close and direct link between their choice to shun certain forms of electric communication and their belief. They did so as a matter of conscience, even though many of a similar persuasion took a different view. In other words, it wasn't a prerequisite of their religion to mandate a prohibition on using computers.
So it was decided that that amounted to an infringement of their human rights, and as a consequence, Revenue and Customs should have allowed them to file paper returns. Who said tax is boring? Well, that's probably the most exciting tax case a tax tribunal's ever had to hear. Lucky them.
We'll finish this section with a look at a case that considered the question of whether it can be discriminatory to require Christians to work on a Sunday, given that some believe that working on the Sabbath is contrary to their beliefs. A requirement to work on Sundays could, in those circumstances, potentially amount to indirect discrimination and be potentially discriminatory unless the requirement is capable of being justified. To be justified, the requirement must meet a proper business need, and there should be no less discriminatory way of meeting that aim.
So in Mbar and Merton London Borough Council, the Employment Appeal Tribunal upheld an employment tribunal's decision that a requirement for full-time staff at a residential care home to work on Sundays in rotation didn't indirectly discriminate against a Christian care worker. The tribunal had been entitled to conclude that the requirement to work on Sundays was a proportionate means of achieving the care home's legitimate business aims. Crucially, though, the council was able to put forward a list of reasons for requiring Ms Mbar to work on Sundays and could demonstrate that it had weighed up the business case on the one hand, but also her need to avoid Sunday working on the other before they arrived at a decision.
Interestingly, this case reinforced the fact that it's not necessary for a claimant to show that working on Sundays had a discriminatory impact in respect of all Christians. It was sufficient that a body of Christians held this particular belief. The case is not a ringing endorsement of an employer's right to request Sunday working of Christian workers. If you employ workers on Sundays and meet this particular challenge, you would still need to be able to objectively justify the requirement by showing that there was no less discriminatory way of achieving your business's aims.